All right, very good. We'll have the marshal call court back into session.
Minnesota Court of Appeals is now in session. Chief Judge Frisch, Judge Cochran, Judge Kirk, the Honorable Jennifer Frisch presiding.
Good morning, Council. Today is November 18, 2025. Welcome to the Minnesota Court of Appeals. This is the second of 6 cases that we are considering on today's calendar, A25-1039, Hardin versus Rekieta and the state of Minnesota. Council, if I pronounce those names incorrectly, please correct me once your time begins. You're familiar with our proceedings. You'll each have 15 minutes for your primary argument. The appellant has an additional 5 minutes for rebuttal. We ask that you identify yourself and your client before you begin speaking. Also, let us know how we can reference you this morning. These matters are being recorded. That is the only recording that is permitted. And with that, Council, we are ready for you whenever you are ready.
Thank you, Your Honor. May it please the court, my name is Oliver Bromke. I represent Appellant Matthew Hardin in this matter. Other parties are the state of North Dakota and Nicholas Robert Rekieta, represented by Mr. White. This appeal centers on the public's constitutional and common law right of access to judicial records in a criminal proceeding, specifically whether uploads to the Minnesota Digital Exhibit System, or MINDES, cited in a party's memorandum but not formally admitted as evidence qualify as public judicial records. The district court initially granted my client, Mr. Hardin's, access to those records, acknowledging their judicial nature, but later reversed course after an ex parte motion by the state to correct the record, denying access without allowing Mr. Hardin a chance to be heard. We're asking this court to reverse that denial and remand with instructions to grant access, or alternatively to afford Mr. Hardin a hearing to rebut the adverse factual findings made against him as an intervener.
Counsel, before you get into the merits of the right to the information itself, I have some questions about the procedure that was used here. I don't see anything in the rules of, this is a criminal proceeding. That's the underlying proceeding. I don't see any mechanism in the criminal rules that allows a private third party to intervene and for this purpose or any other purpose. Can you point me to some authority that allows for that procedure in a criminal proceeding?
Sure, Your Honor. Intervention is the canonical vehicle for third-party access enforcement. I believe the case I cited was Providence Journal, especially when there's a First Amendment issue lurking here. Criminal cases demand public scrutiny to keep the system accountable, especially in situations like this one where it appears that the prosecution and the defense in the underlying criminal case were of the same mind and filed a motion that both of them constructively adopted.
But the mechanism in that case was not intervention in a criminal case, was it? I'm just not aware of any authority that allows a private third party to intervene in a criminal case to seek the kind of relief that you're seeking. I'm putting aside the question of whether you have a right under some other procedure. I just am questioning whether this procedure is authorized by law or our rules.
Well, the right to intervene here, it flows from the constitutional right of public access itself. Under the cases I cited, Sargent and Ledoux, procedural rules can't.
But Mr. Bromke, I think the question is there any rule of criminal procedure that allows for intervention in a criminal proceeding to access court records?
I believe that the district court in the order that allowed for the intervention for the limited purpose specifically pointed to the common law right of access with respect to its basis for allowing Mr. Hardin to intervene for purpose of making the request that he did.
And I think the court noted that there wasn't any specific criminal rule of criminal procedure that would allow for intervention, correct?
I believe that is the case, yes.
And so isn't there another procedural mechanism that is available and provided for, which would be a petition for a writ of prohibition or a mandamus to seek access to judicial records, as has been used in some of the cases that you cited?
Had the court outright denied our request, we would have sought relief in that manner, but in the interest of judicial efficiency, we sought access this way instead.
And you can still seek access through regular civil proceedings. Yes?
Yes, but with respect to challenging adverse factual findings in the writ of mandamus context, I'm not exactly certain how the court expects us to do that necessarily. It's just a constitutional principle that we're asserting here.
I understand, counsel, but it does seem incongruous for a third party to be seeking a civil remedy, which, the collateral consequences of which delay a criminal proceeding. And I have constitutional concerns about that also.
Well, I mean,
And is there any jurisdiction anywhere in the country that allows for this kind of procedure?
as a matter, well, in terms of, you previously asked about whether Minnesota specifically allows for it. Minnesota rules of criminal procedure don't explicitly incorporate a remedy of this type, but many jurisdictions, including the federal courts, routinely recognize it, and we cited that in the district court brief.
Routinely recognize what? A right of intervention in a criminal case?
Well, for the purpose of seeking public access to court documents.
What's the best case that stands for that proposition?
Apologies, looking through.
Or is there a rule of federal criminal procedure that allows for intervention for purposes of by a third party for purposes of obtaining a civil remedy? I mean, Mr. Bromke, you can see what our concern is. I mean, this isn't the only criminal case where there's evidence that is produced, and I have concerns about allowing for civil intervention that would necessarily delay criminal proceedings, as a matter of procedural course, which is probably why we don't have a rule of criminal procedure allowing for it. So why would we allow this kind of procedure to occur as opposed to directing your client to engage in regular civil remedies?
Because the result is going to be the same regardless. We're going to be arguing about the same issue, and this is simply the most convenient forum in which to litigate it, given what's already been filed.
I mean, the result might be the same for you, but the result is not the same for a criminal defendant. Wouldn't you agree?
Well,
Wait.
That's true, but in this case, the underlying criminal case is already more or less concluded. We've gotten past the disposition phase. The state is arguing we're stopped by this criminal order from making arguments in the civil case. So in terms of who this materially affects, I would say that it's us.
Can you point me, let's just turn to the merits for a moment. Can you point me to where in the rules of public access to judicial records that indicates that a document that was never received as an exhibit, was never, there was an administrative error in entering the document in Mindy's, that administrative error would render the document an exhibit for purposes of determining whether it is a public record?
Well, the public access laws talk about what's presented, not what's offered and accepted pursuant to the evidentiary rules. Presentation is a broad term. You've got Minnesota's rule on sanctions, for example, saying you can't file or present to a court a motion without 21 days notice. It's got to be considered a distinct concept from offering, or else it's surplusage. Here, the body cam footage at issue was presented by a criminal defendant, Nicholas Rekieta, in support of his motion to suppress, in which he accused.
Well, it wasn't presented, though. It was cited in the motion. And my understanding is typically in a criminal proceeding, a legal brief framing the argument that will be, the legal argument is filed, but the actual exhibits are not filed. They are offered at the hearing. Now you can talk about that in your response, but I don't think it was presented. I think the record reflects that it was cited in the legal brief and uploaded into Mindy's. And as you know, Mindy's is a newer system, and there is a Supreme Court order governing that, which says specifically that exhibits in Mindy's offered in court proceedings are case records, exhibits uploaded and stored in Mindes, but not offered to the court are not case records of the Minnesota Judicial Branch as defined in the rules of public access and are not publicly accessible. So
Right. Oh,
I
sorry.
think the question is not whether it was, you're using the word presented. I think the real question is whether these video exhibits were ever offered.
And I would take a different position. Offered and received are evidentiary terms of art. They govern what becomes part of the evidentiary record for purposes of proof at a hearing or trial. But the right of public access doesn't turn on evidentiary admissibility. It turns on whether a document is presented to the court for purpose of influencing a judicial decision.
And what case are you citing to? Because I think the case law talks about documents being filed, not presented. So what case or rule are you relying on when you're using the word presented?
The specific issue at hand here is so new, given the newness of Mindes, that I don't believe that there is a specific Minnesota Supreme Court case or appellate court case on point to that issue. But the distinction is built into.
Aren't we guided by the Supreme Court's order? I mean, why wouldn't we follow the Supreme Court's order that says that unless a document in Mindes is offered, it's not publicly accessible? We are an error correcting court. We are bound by Supreme Court orders.
Because the distinction is important for preserving the right of public access by interested individuals and holding the holding the parties to a criminal action accountable for what they filed. The distinction matters because presenting is the functional act of placing a document before the court to adjudicate rights. But
you have no legal authority to support your position on presenting.
The Minnesota Government Data Practices Act specifically says presented items that are presented are public. It doesn't say anything about offered versus accepted.
I mean, the Data Practices Act doesn't apply to judicial records.
Granted, but I'm referencing that for the purpose of establishing that there is a distinction between them here. I mean, regardless of what the Supreme Court has specifically said about
and in the Supreme Court's rules of public access, does it draw the same distinction?
It does not, to my understanding.
Counsel, why can't you just handle this as a data practices case?
It's being handled as a data practices case, but unfortunately, we are currently waiting for that to resolve. Whether or not that case proceeds and how it proceeds is going to probably depend on the procedural posture of this case pending this hearing. So,
but I mean, what at this point, if the investigation is over, what basis would law enforcement have to claim that it's not a public record under the Data Practices Act?
Wonderful question. If you could ask the same question to the district court judge in that case, we would love it. But the findings there are adverse findings in this criminal order that we're appealing. In terms of the specific data that we're requesting, there's some, I guess, not quite. There are some minor children that are involved in the footage that would create some pause for law enforcement from releasing it. And we made Government Data Practices Act requests and they were denied. And that's currently the subject of civil litigation.
So, counsel, in your view, when did these video exhibits that were never formally offered, when did they become judicial records in your view?
At the point at which the district court reviewed them for the purposes of at the point at which the court reviewed them after they were filed by Mr. White in advance of the omnibus hearing, when the court took a look at what was filed and said some of this is properly brought at the motion in limine stage rather than at the pretrial or at the omnibus hearing stage. At And then certainly later
That
on,
was after they were mistakenly marked as admitted.
no, before that they were mistakenly marked as admitted.
Well, the request for access was after the omnibus hearing.
Right, but you asked my position on when they were,
Yeah, and maybe I misunderstood your response, but I thought you said it was when the court reviewed them, and I thought the court reviewed them for determining providing public access.
they did, yes, on May 1st as well. There's another order. There's two separate times at which the court reviewed the evidence that was submitted by Mr. White. One was during the criminal case when it was ongoing, and then there was afterwards for
So
the
wait, I'm sorry. When are you saying exactly the court reviewed it during the criminal case?
in advance of the omnibus hearing at which it determined that the issue that Mr. White had brought up was more properly brought as a motion in limine issue.
And what's your basis for saying that the court reviewed it because the court in its order said it didn't rely on those exhibits?
Because the statements that were made by the court specifically say that it was a motion in limine issue, not an omnibus issue.
I don't know that that means the court reviewed the exhibits. I don't think the court actually said that in the transcript. So you're inferring something that isn't expressly there. Would you agree with that?
Not necessarily, no.
Can you point me to where in the transcript you think the court said it reviewed the exhibits?
Well, it did that in advance of the May 1st order, which it specifically stated. It described what was the content of the video.
Well, where in the record can you point me to support your view that the court reviewed these exhibits prior to the omnibus hearing? You need to support your position with the record before us. That's what our review is limited to.
Apologies, reviewing the transcript here.
Because we're familiar with your briefs, we're familiar with the transcripts and the record. And I don't recall that, but maybe I'm just not recalling it at this moment. Well, you can answer on rebuttal. Your time is up. Thank you, Chief Judge Frisch.
Of course. Mr. Bromke, you will have 5 minutes for rebuttal if you choose to use it. Mr. White, I understand from our coordinator here that you're intending to split time. I didn't receive a notice that that's what the intention was. Is that correct, though?
That was correct, Your Honor. But Mr. Baker's late arrival may prejudice him against his ability to respond to the questions the court asked the appellant.
What would you like? I'll just say, what would you like to do?
I'll handle it all, Your Honor.
Okay. All right. Mr. White, you'll have 15 minutes. Go ahead, sir.
Thank you, Your Honor. Your Honor, my name is Francis Herbert White III. I'm here on behalf of Nicholas Rekieta, who is the defendant in the underlying criminal case and one of the respondents in this matter. As a defense attorney, I find myself in the very strange position of being on the same side of the V as the state. I never really thought that would happen, but here we are today. And like the court is, I don't understand, the court has expressed to Mr. Bromke, I do not understand by what authority Mr. Bromke has brought on behalf of Mr. Hardin this action in this court, especially when you consider the fact that shortly after initiating this appeal, sending this matter up for an appeal, he filed the public access lawsuit in the district court, which would be the more appropriate venue for answering these questions. I agree with the court that the rule that the Supreme Court issued under MDES is in fact binding upon this court and is in fact binding on all of the courts.
Can you help me understand when this request came in, every time the district court had to consider this request or the intervention request and the request for the documents, did you and your client have to appear at those hearings?
As far as I know, there were no hearings.
There are no hearings. Okay. And so did this procedure delay the resolution of your client's case?
Well, I'd like to remind the court that my client is still under the jurisdiction of the court because he has a stay of adjudication. So despite Mr. Bromke's assertion that, that this case is quote unquote more or less over, it isn't more or less over. There still are criminal sanctions that are potential. And therefore the case is still, I wouldn't call it pending, but it's not over.
Well, before the stay of adjudication was entered, was there any delay associated with the processing of your client's case, associated with these requests? I'm just wondering how this worked. This is a very odd procedure to me.
Your Honor, I am not in a position to answer that question because any delay that would have come from there would have been on the state of Minnesota, not on me. Mr. Bromke's communications with the state of Minnesota, I was entirely unaware of them until I had been informed by Mr. Baker that they were in fact asking the court to do something. I did not know anything had transpired before that because there is a different procedures, an administrative type procedure to which Mr. Rekieta was not joined as a party. So while Mr. Bromke is here objecting to the fact that he wasn't allowed to assert his constitutional rights to a right of access and afforded due process, the same could be argued of Mr. Rekieta in that administrative hearing. He got an order from the court granting the limited access that he had without Mr. Rekieta being put on notice that access was even being sought. So there are two different constitutional provisions here at work. One is the constitutional right of a defendant to due process and equal protection, as well as a First Amendment question. And if Mr. Go ahead.
Is it your position that requests like this are critical stages of the proceeding for which a criminal defendant must be present for the consideration of the release of records?
Not necessarily, Your Honor. It is my position that the defendant should be notified that there is a request. I fully agree that the district court has it within its authority whether or not there should be a hearing or not, or whether it will just accept submissions on the record. I haven't seen any governing authority that requires a district court to have a in-person or a Zoom hearing when the record suffices. As a matter of fact, this court very frequently, if a party is unrepresented, will not schedule oral argument. Those people are not deprived of due process by just deciding the information, making the decision on the briefs alone, even though the parties didn't get a chance to present oral argument.
Mr. White, are you aware of any legal authority that would permit intervention in a criminal proceeding to seek access to case records in that proceeding?
No, Your Honor, I'm not aware of any that would prohibit, and I'm not aware of any that would allow it. The only thing that I would have to rely on is the order from the Supreme Court as regards to MDES. And as MDES works, it is a staging platform. And until such time as that evidence is offered and admitted, it's simply there waiting to become a record. It is not at this time a record.
And counsel for the state isn't here part of the oral argument, unfortunately. But from the briefs, it appears that your client, as well as the state, is of the view that intervention wasn't appropriate. Can you respond to that question or comment on that point?
Yes, Your Honor. The rights of a party or an individual to intervene in a criminal case should be reflected in the rules of criminal procedure. Now, I do know that when you appeal a criminal matter to this court, you sometimes rely on the administrative rules of civil procedure, but that's because there are no other rules that guide that. I'd like this court to think of what the consequence would be to allow intervention in a criminal proceeding beyond what Judge Frisch has suggested might actually happen in the delay of criminal adjudications. It would open up an argument for individuals to potentially initiate private prosecutions. Now, there are a lot of people out there who would probably love to engage in a private prosecution, particularly of government officials with whom they disagree. But that would create a problem, not just with the courts, but with the due process of the individuals who are being charged privately. I think by allowing non-parties to enter into a criminal proceeding, you are opening up a Pandora's box that will have a sort of Damocles over the judicial system.
Thank you. With regard to the legal issue in terms of access to the records that was decided by the district court, what standard of review do you think is applicable to the district court's decision to deny access?
That's an excellent question, Your Honor. As a defense attorney who's normally on the other side of the V, I would argue that this should be granted de novo review. But I don't think that that's proper, because there is no legal authority that was applied to the case to allow intervention. I think an abuse of discretion standard would be there. The appellant has not been able to cite to any authority that would grant him the relief that he sought. Therefore, I don't believe that de novo review is appropriate, because it's not really a question of law, because he can't make it a question of law.
I'm sorry, Judge Kirk, were you about to ask a question?
No.
Appellant also argues, or counsel for appellant argues, that the district court reviewed these videos and therefore they are now court records that should be accessible. Can you respond to that argument? First, in terms of whether you think the record reflects that the court did review the videos, and if so, when, and then second, does that change our legal analysis in terms of the Supreme Court's order on relating to Mindy's?
Yes, Your Honor. To begin with, I don't believe that the district court reviewed the videos, at least in the criminal proceeding. I can't speak to the other proceeding because my client was not privy to it. However, in the criminal proceeding, it was not reviewed. And it is clear that it was not reviewed because there's nothing in the record that says that it was reviewed. And the district court judge clearly stated in his order that he did not base his decision on the videos. Mr. Bromke has suggested to this court that the district court judge's assertion that this was more appropriate for a motion in limine proceeding is misguided, and proves that he must have reviewed the videos is misguided, because any judicial officer in this state can glean that exact concept from the actual brief that I filed, where I put in there the specifics of what I was asking the court to do. I asked the court to review this, and if you look at the transcript, you can see in the transcript he did bring that up, and I said I wanted to make sure that this was timely, because I had found another case, I believe from this court, that had stated when somebody brought it up in a motion in limine, they had that, and they should not have brought it up. They should have brought it up sooner, even though the district court was wrong. That was not reversible error. That was harmless error. So I agree with the court. It's not in the record that he reviewed it. There's nowhere in the record that he reviewed it.
Well, in terms of the omnibus hearing, but I think the court's order initially granting access suggests that the court did review it because it talks about you know, the contents of it in terms of there being children present when the search warrant was executed. So and that is in Mr. Hardin's addendum, I believe, at pages 22 and 23.
Mhm.
So does that change our analysis in terms of whether that, given the administrative error in marking it admitted and then the court's review for purposes of the records request, in terms of whether the Supreme Court's order on Mindy's applies?
Your Honor, I don't think that that order gives us a heavy lift as the appellant is suggesting, because there was a previous filing in the criminal case that I filed where I objected to individuals who had filed a request to record the omnibus hearing. And in my brief, I said that there were children present. And I do believe I said there were children present in the body cam video in that brief. This was prior to my brief on the omnibus itself, I believe. So the court could very well have gleaned the information that there were children present from that, unless the district court specifically stated that it reviewed that. And finally, Your Honor, I would like to say this is more appropriate for the Data Practices Act. I looked at one of these two proceedings is a collateral attack on the other. This is not a proper proceeding before this court. The district court can access this under the Data Practices Act. The plain language of the Data Practices Act says that it doesn't apply to judicial records. Judicial records are governed by the judiciary. And the Supreme Court of this state has spoken just to that. As far as
there isn't any legal bar to someone seeking a record that might be retained by the executive branch and the judicial branch at the same time that I'm aware of. Are you aware of any? I mean, are you aware of any law that would preclude submitting two requests, one to the executive branch and one to the judicial branch?
I'm not aware of that, but as I stated before, one of these two is a collateral attack on the other proceeding. I see my time has expired. Unless you have any more questions, thank you, Your Honor.
Is there anything else from the panel?
No.
All right, thank you very much, Mr. White. Counsel, you'll have 5 minutes for rebuttal.
Thank you, Your Honor. A motion to intervene is appropriate to assert the public's right of access in criminal proceedings. I've got some federal case law in here, In re Herald Company, 734 F. 2nd 93-102. Vindication of the right of public access requires some meaningful opportunity for protest by persons other than the initial litigants.
Was that a criminal proceeding?
Uh,
I mean, my concern is that in the civil rules of procedure, there are specific rules that allow for intervention, permissive intervention and intervention as of right. But there aren't corollary rules in the rules of criminal procedure. And I don't think in the rules of federal or the federal rules of criminal procedure either. Although I could be mistaken. I'm not as familiar, obviously, with the federal rules. Is there some authorized procedure here?
With respect to the rules of criminal procedure in Minnesota, I think we've established that there isn't a specific rule that allows for an intervention of that type. But This isn't some improvised procedural maneuver. It's a routine, nationally recognized method for vindicating a constitutional right that belongs to party, or not to the parties, but to the public.
Is it though? I'm waiting to hear about criminal cases where this has been allowed.
I would request that the court grant some additional time to file some supplementary authority to that point. Just because the constitutional question here is an important one. It's the public access to criminal court records in a case where the defense and the prosecution have both taken the same position. US v. Arif 533 F 3rd 7281 is expressly criminal. The other conditions, or the other citations that I have pulled up here are appellate petitions for mandamus forcing district judges to grant mandamus. But in United States v. Arif 533 F 3rd 72.
But mandamus is a civil proceeding.
No,
Yes.
In US v. Arif, the court reaffirmed third parties seeking access to judicial records can intervene directly in the criminal case to assert that right. I believe that's representatives of the press. The court accepted the procedural route as an obvious, uncontroversial way of doing it because access rights attached to documents and proceedings in that specific file. And the district court should follow the same rule. It's a natural way of.
And what case is that? Can you tell me that case again, please?
United States v. Arif 533 F 3rd 7281, Second Circuit 2008.
All right, thank you very much.
Representatives of the press intervening to challenge closure and sealing orders inside a criminal matter itself is something that you would need to actually file into the criminal matter in order to do. So procedurally, it makes perfect sense.
And those were cases where there was a challenge to the closure of a courtroom?
I believe that case in particular, I'm not certain of the exact factual pattern underlying it, but
Closure of a courtroom is different than requesting a document. And
that's correct. I was referring to some of the other cases I was going to be citing, but the United States v. Arif is an expressly criminal case, and the issue at hand is access by the public to documents in a criminal case. So I would submit that that the same principle is applicable here, especially given the public policy concerns of two parties that are nominally adverse, trying to coordinate to restrict the public access to those records. Procedural rules can't be interpreted in a way that diminishes constitutional rights. I mean, the cases I cited, Sargent and Ledoux, hold that procedural rules can't do that. Schumacher and Star Tribune recognize a constitutional and common law right of access. The method specifically by which it's enacted, I think, matters less than the public's interest.
But you could still have a right to access through a writ of prohibition or a writ of mandamus, correct? So the question here is whether intervention is the appropriate avenue.
Whether it's the appropriate avenue, but whether it's impermissible, I would argue that it isn't. But in a criminal case, the most direct method of gaining access to specific records you want is simply to file into the criminal case itself. I recognize I'm out of time, so.
Anything else from the panel? All right, thank you very much, counsel, for your helpful arguments and submissions. The matter is submitted. We will issue an opinion within the statutory time period. Thank you again. Have a good day.